The defense lawyer for 4 of the accused in the Senzo Meyiwa murder trial has asked the magistrate in his assault case to recuse himself. Advocate Malesela Teffo was arrested last month for contempt of court after missing his court appearance on assault and trespassing charges. He appeared in the Hillbrow Magistrate's court on Friday, where his lawyer Timothy Thobane told the court that there are 2 complaints against the magistrate. Joining us to unpack this a little further is Advocate Romeo Nthambeleni. Advocate, thank you so much for your time, and thank you for joining us this morning. Perhaps let's start with you taking us through the different instances wherein a judge or a magistrate can, in fact, recuse themselves, or would have to at least entertain a recusal application.
Yeah, thank you. Good morning, and also to you and the viewers and the listeners alike. The doctrine of recusal has its origin, from the rules of natural justice, and it says that every accused person must have a fair trial, and this doctrine is a common law position, and it was entrenched in the Constitution, also in Section 35 of the Constitution, that says every accused person has a right to a fair trial. And then a recusal comes in when there are grounds that are actually established where a presiding officer, either a judge or a magistrate, has to actually recuse himself.
I think the last sort of high-profile instance we at least witnessed where a recusal application took place was in the case of former President Jacob Zuma asking Chief Justice Raymond Zondo to recuse himself from the State Capture Commission of Inquiry. I guess, the question for a lot of South Africans in this instance is, are recusal applications, commonplace?
Yeah, not really that common in practice, in terms of where you are asking a presiding officer to actually recuse himself. But when there's a grounds and there's basis in law for such a recusal application to be made, they are rarely made. So they are not a common feature in practice on a daily basis, where you find that parties are asking a presiding officer or a judge to actually recuse themselves. You have given a highlight of an important example. There are several cases where we have seen presiding officers, as in judges and magistrates, being asked to recuse themselves. And we said that it should come in a form of a substantive application. It's not just there for a taking. You bring a required application that you must substantiate with solid reasons why you should, the presiding officer should recuse himself. So when those bases are established, that's why in the matter that we're talking about of Teffo, there's going to be an application that is a comprehensive application with reasons why they want the magistrate to recuse himself. And don't forget that in terms of the Constitution, the magistrates and also judges, they take the oath of office to apply the law without fear, without favor, and without prejudice. And when the element of prejudice has been established, that's when a recusal application, it's in order.
I think, for a lot of our viewers, the presumption is that, judges are unbiased. And so it'd be interesting to hear from you, Advocate, what sort of grounds one would have to prove to see a judge or a magistrate, in fact, recuse themselves. You've mentioned that there have to be, substantiated facts, but what are some of the grounds that would have to be proven?
When you have a particular interest in the matter that is at hand, let's give an example with the one that you have referred to of the former president and the current Chief Justice Raymond Zondo. What was raised there was that there is a friendship that has actually existed between the two, and then that reason create bias. So it means that when you know the person outside the framework and the realm of court, you are going to be biased. You're not going to apply the law as you are required to do by the Constitution without fear, without favor, without bias, and without prejudice. And in the instance of the matter that we are discussing at hand, there's an indication that Teffo indicated that he has reported the said magistrate to the Magistrate Commission. So obviously, in that instance, you are not going to apply the law without fear, without favor, and without prejudice. It means that you are going to look at justice with a jaundiced eye. It means that you are going to look at justice, thinking in the back of your mind that this is the person who has actually reported me, if those facts are established in their substantial application that they're going to prove. So you need an independent mind when you're dealing with a matter. You are not supposed to be biased. So I think those are instances where bias can be established. And it's not an easy test, as you have seen with the matter of the former president, Jacob Zuma. You have, it's a high thing that you actually have to prove yourself, the one that is actually alleging that there's bias. So it's not an easy thing that is there for the taking.
Yes, well, in this case, Advocate Teffo has, in fact, laid a complaint against the magistrate with the Magistrate Commission. I wonder if, even in an instance like that, a judge or a presiding officer would still be able to, in fact, put aside their biases. Because I'd imagine in any sort of judicial training, you are trained to be able to put aside your biases. The idea that judges are these inhuman individuals who don't contain any biases is something that has been debated for a long time. So I wonder if a judge is still expected in some instances to put aside their biases, where it has in fact been established that there may be some prejudice at play.
No, you're quite correct. It's true that the judges are not non-terrestrial beings. They are affected by by things like every other individual. But to establish that test is very difficult. Because you might find that being reported doesn't actually make you to be impartial. You have to prove it. That's why I'm saying that the test is very high to actually prove. The fact that you've reported me that might not actually make me to rule a case against you. I can actually rule in your favor if you have got the facts and the law actually favor you. So the mere fact that you have reported me does not necessarily mean that I'm going to be biased in your case. And as you have actually rightfully said, that the judicial training in this country expect you to be independent under all circumstances. Then if you are not, then you are not supposed to be even a judge or a presiding officer or a magistrate in the first place. So you are correct to say that it might be difficult, very difficult to actually prove that the mere reporting of a presiding officer will make that person not to be eligible to preside on your case. So it means that in cases where most of these presiding officers are reported, then many cases will not be had.
The other important issue, Advocate Nthambeleni, is the fact that Advocate Teffo is, as we know, representing 4 of the accused in the Senzo Meyiwa trial. Now, I would like to just play a quick bite on a comment that he made with regards to that trial. Let's just take a quick listen.
That has been continuing anyway, but it's not disturbing us. We are not deterred. We are not deterred because if when we walk everywhere with my attorney, myself, my attorney, and whoever is on our side, people are saying, guys, you are doing a good job. Proceed. We want to see this case at the end. And definitely we don't want to disappoint the people of South Africa and those who are peace-loving and the people who are in need of justice in this country. Because if you can understand that this matter, the Meyiwa matter, is one of those matters where many families didn't see justice. So, likely enough, for a long time, there has been a lot of judges of the Court of Public Opinion. Ultimately, we've got the real judge before the court, that's the North Gauteng High Court. The matter has started and is going to be finalized. We don't anticipate any unthinkable incident that can disturb this matter.
Well, you heard for yourself there, Advocate Nthambeleni. I mean, how true are Advocate Teffo's assertions there that his own personal legal developments aren't in any way going to impact the Senzo Meyiwa trial? To me personally, it seems that it would at least be, distracting at the very least.
Unfortunately, I'm not certain because the trials are set, and then there are time frames that are set for trials to be run in court. And if you have another case that is actually pending against you and it's impacting on the trial, it might actually have an adverse effect, which you have unintended consequences. So, you have got appearance, your matter is being postponed. A trial has a psychological effect on a person. So I'm not certain. Perhaps he has checked himself. I'm not dealing with the matter. and he has verified that whatever is actually happening is a sideshow, and he can continue to focus on the job that is at hand. But for me, I'm just worried about dates and the times that are set for trials, so that if there can be clashes, then it might actually have an impact on the very same justice that is actually talking about that justice must be done, because if ever he's going to court and the matter has to be postponed on his account for him to actually deal with his personal matters, it affects the trial. It has an unintended consequence of actually affecting the trial at hand.
You know, another development that we've learned is of course that Advocate Teffo is a career cop turned lawyer, and in fact a number of the cases that he's taken on are whistleblowing cases within the police service. And there's I suppose an idea circulating, or speculation at least, that he is being targeted here. He's the target of a stream of attacks from the judiciary, or law enforcement in general. I wonder what sort of recourse lawyers have in instances like this, because it is a job that is risky, especially if you are dealing with cases such as whistleblowing cases, particularly around an institution such as the South African Police Services.
Yeah, lawyers are like everyone else. They have to report their cases and open the cases with the very same South African Police Services, and cases have to be investigated. And if there is merit, to the investigation, arrests have to be effected, and then perpetrators being brought to book. So basically, that is what is supposed to be done, and also to escalate the matters with the Legal Practice Council of South Africa to actually look into the investigation of what is actually happening, so that justice will prevail at the end of the day. So the Legal Practice Council protects the members in relation to the work that they're supposed to do, because as a legal practitioner and as an advocate of the High Court, you are an officer of the court, and you are supposed to do your work without fear, without favor, and without prejudice. So if the case is open and the investigation is done and there's merit in the case, then the police can take the matters further. But the problem is when you have a challenge and you are saying that the very same police that you want to report their cases are against you, then it becomes a bit of a problem as to where you're going to go now.
Indeed.
But you have to report at least the case, so that there can be a case number and there can be a tracking of that case and see how far it has been investigated or not investigated, so that when you escalate to the LPC, at least you have got a basis of an investigation that was conducted or not done.
Right. Well, Advocate, thank you so much for your time and for joining us this morning. That's legal analyst, Advocate Romeo Nthambeleni, joining us there to talk to us about Advocate Malesela Teffo's legal developments.